Hi, my name is Natalia Gavlin. I'm an immigration attorney in New York City, New York. Today I wanted to explain to you the process of filing a family petition for a spouse. So the first step of the process is for the petitioner, who is a U.S. citizen or green card holder, to file a family petition Form I-130 for their spouse, who is called the beneficiary. Now, the process is slightly different for a petitioner who is a green card holder as opposed to a U.S. citizen, depending also on the status of a beneficiary. So I would like to first tell you what happens in a situation where a U.S. citizen marries someone and would like to petition for them. We need to take a look at the manner in which the beneficiary entered the United States. Because if the beneficiary entered the United States on some sort of legal status or a visa, meaning they were inspected or paroled at the border and were issued I-94, in that case, the beneficiary does not need to leave the United States and can simply file a green card application to adjust their status along with their family petition Form I-130. If, on the other hand, the person entered the country illegally, by crossing the border or being smuggled into the country or in any way that was not inspected or paroled, in that case the beneficiary will not be allowed to file for adjustment of status in the United States. Previously, a beneficiary like that really did not have means to adjust status or get an immigrant visa. After the provisional waiver was enacted, now the petitioner can file Form 601A for the beneficiary to be allowed to return back to their country so that upon processing with the counselor, they can return back to the United States and their unlawful presence will be excused. Now, if the person, for example, the beneficiary, who is married to a U.S. citizen, is in an illegal status, so to speak, right? So whatever status they were in possibly expired or, they entered here legally, that will be excused if they're married to a U.S. citizen. And that is the biggest difference between a green card petitioner as opposed to a United States citizen petitioner. So at this point, I would like to tell you what happens in the process if a person is married to a green card holder. So again, it is very important to look at the beneficiary at the time of filing. If the beneficiary is in legal status on some sort of a visa or any other way, then they technically could adjust status in the United States when the visa number becomes available. And they have to be careful to maintain their status, because if at any point they fall out of status, they need to return back to their country to adjust status. In addition, there is no provisional waiver available for the spouses of green card holders. So a person like that who is present in the United States unlawfully or has been here illegally for a number of years cannot adjust, because the provisional waiver will not apply for them. And generally the timeline of the application and the petition also depends on the status of the parties at the time of filing. For example, as you can understand, United States citizens have faster processing times for their spouses as opposed to green card holders. For the green card holders, they need to wait for visa number to be available, and this information can be found in the visa bulletin that is posted monthly on the Department of State website. Normally, the way the process works is a family petition is being filed, and then you wait for it to be approved. Upon approval, the person can then file adjustment of status. Like I said before, if a person is a U.S. citizen, they can technically file family petition along with their green card application for their spouse at the same time. The process is quite complicated, and as you can see, there are a lot of variables depending on the status of both the beneficiary and the petitioner. So to make sure that you proceed in a proper way, I highly recommend that you consult with an experienced immigration attorney who can make sure that the person is eligible for adjustment, and also that there are no bars or no problems in the situation that might prevent them from being adjusted or considered inadmissible. If the person who is a petitioner, is a U.S. citizen, and they're filing Form I-130 along with the green card application 485, they will usually have only one interview with an immigration officer where both spouses have to be present. Actually, for all the family petitions, the burden is on the petitioner and on the beneficiary to prove that the marriage they entered into is bona fide, meaning that it's true marriage, it isn't for immigration purposes, and you need to present evidence to prove that it is in fact a bona fide marriage. People often ask what kind of documents are necessary. I would just say it depends on the situation, but in general, USCIS is looking for documents that shows that you have a relationship, meaning documents that are issued in both of your names, documents that you would expect normal couples, I shouldn't probably say normal, but a regular, typical couple, at least for USCIS standard, to have. So we're talking about leases, we're talking about utility bills, insurances, car documents, any information that can show that this couple is married and that they are legitimately married and that their marriage is not for immigration purposes. So usually what I would do, and what I think people should do, is they should look at their own situation, and if you're lacking, for example, a lease in both names or any other document, then you can probably make up for it in some other way. Sometimes it takes quite, creative approaches to come up with documents necessary, but in general, we're usually able to come up with a decent packet of documents, including letters from friends, photos, tickets, travel arrangements, anything that can show that the couple has been together, they know each other, and they're living the life that's expected of a husband and wife. Or for LGBT community, for same-sex marriage couples. Again, if you have any questions, I think you should definitely start by consulting with an attorney. And, good luck. Thank you.